During today's program, we'll hear from two employment law experts, Mariana Granhoy and from Kroman Reumert and Anne-Marie Abrahamson from Lundgrens, on the following topics from an employment law perspective: the handling of mental health issues related to remote work, changes in terms and conditions of employment, impact on salaries and incentive schemes, and legal frameworks for conducting redundancies. After each of these segments, we'll do a brief Q&A. And additionally, if you have extra time after the event, we'll do an informal Q&A from 10:15 to 10:30. So if you can, please stay on the line and remember to add your questions in the chat function at any time. And please remember to mute your microphones if you have not done so. Now I would like to introduce Mariana Granhoy, who will talk about the handling of mental health issues related to remote working. Mariana?
Thank you very much, Therese, and good morning, everyone. I am going to speak a little bit about handling mental issues related to remote working. And this is, I'm sure, very much on everyone's mind at the moment. And I'm also very cognizant that this is a topic certainly not purely legal, very much within the field of everyone's expertise on this call, being a genuine HR concern. But what I will try to also is elaborate a bit on the legal framework surrounding this topic, because we're all, of course, facing now the challenges of remote working having going on so long and causing a lot of frustrations and also mental health issues in companies. In preparing for this session, I have been in contact both with unions and also some of the pension companies, and all of them confirming that we are in a phase of the pandemic right now, and the duration of the remote working has been going on for so long that we are seeing some of the more worrying long-term impacts of people having been lonely in their homes for a very long time, and that's some of the aspects that I'm going to touch a bit upon in going through some of the considerations that needs to be taken by employers for the time being. And also wanted to add, especially knowing that many of you are from global companies and also with foreign backgrounds, many of you that at least in Denmark, I think that we also have to keep in mind that remote working and not having long distances between work and home sort of traditionally also implies that this whole new transition into remote working has been, on the one hand, remarkably well done across the country, I guess, but at the same time also we have not very much experience with it. So again, being prepared for the long-term impact is really what is on top of mind of everyone at the moment. And adding then, I then want to turn into some of the legal aspects of mental health issues, because we are of course within the framework of the Danish working environment legislation, sort of the umbrella act and legislation being the Danish Environment Act, where the health and safety regulation is embedded from a Danish perspective. But it then also includes a lot of statutory orders, and also including one that was updated and consolidated in September last year in Danish, bekendtgørelsen om psykisk arbejdsmiljø, an actual sort of very targeted statutory order under the working environment legislation in terms of mental health. And for those of you that may not have sort of, a deep, detailed knowledge of the statutory order, I think it actually does include quite a few sort of important aspects, both obviously because it is in fact hard law obligations on the employer, but also because it sets out the framework and reminds some of the aspects that are important to take into consideration, which sort of embraces everything from working time, endless days, lack of breaks, lack of clarity in terms of working conditions, and all of these elements that can easily flow into a remote working environment if that is not very carefully steered from the employer side or from an HR perspective, and obviously then adding or contributing to the challenges of the individual employees being at home with not sufficient guidance on how to monitor or structure their working days, that in itself can cause a multiple variety of challenges, and ultimately, again, from an employer's perspective, not only cause health and safety issues for the employee, leading to illness and the like, but certainly also a significant loss of productivity, which again is also what I'm hearing at the moment, that quite a few companies are reporting on a very successful entrance into the remote working space, but also that currently we are seeing a lot of sort of challenges in keeping up motivation, keeping up good spirits, and also productivity, which is not only related to the work itself, but obviously also because many people are struggling not only with taking care of their job, but also taking care of their children's schools, what have you, even though the latest opening up of the school should hopefully I'm just getting a little bit distracted because I just had a report here saying that my sound is not very good. Is that a general sort of observation here?
Not with me, Marianne.
Okay, I'll just keep an eye on it because otherwise I may have to change my my headset. But just to capture. Okay, thank you very much, everyone. Hopefully it was only one having this issue. But just sort of to come back to that structuring the working day and having the managerial attention to all of these issues with the individual employees, and also being very much aware that it comes out differently depending on each of the employees, is also something to keep very much in mind. But that it is also important to train managers, and we're also seeing that many of the companies at the moment are sort of taking their competences into the next level in terms of making sure that not only their employees are being well taken care of in terms of their working environment, but also that managers are being trained to actually lead their staff in a remote environment, which obviously in a virtual world requires specific competences, and it is a special dynamic to actually lead a team from the distance.
Okay, so Marianne is suggesting to switch to me. So I think, Isaac, if you can turn to my slide, then we'll do my slide and come back to Marianne and do the Q&As. Well, everybody, I'll take you to the next issue here, which is something that has kept the employment lawyers busy through the pandemic. The questions regarding the possibility to change terms and conditions of employment. And the questions that has been raised to us as employment lawyers have been many. It is questions regarding salary reductions, for example, as part of a cost reduction exercise. It's a question about reducing the number of working hours. It's a question about changing of workplace. And the legal framework in connection with handling changes in terms and conditions. I'll take you through the legal framework, and then we can talk about some practical solutions in the end. There is a distinction that is very important when we talk about changes in terms and conditions. It's the distinction between material changes and insignificant changes. That's always the exercise you have to do, because insignificant changes can be implemented by the employer by the use of the managerial rights without notice or with what we would normally call a reasonable notice. And a reasonable notice would then obviously depend on the nature of the change. If on the other hand, it's a material change is in fact regarded as a termination of employment on existing terms combined with an offer of employment on revised terms, and therefore an employer cannot unilaterally impose such changes on an employee without respecting the individual notice of termination for each employee. And to give you some guidelines in terms of considering changes, what is material changes and what is not a material change. Typically, all changes that has a monetary impact to the disfavor of the employees will typically be regarded as material changes, even though the change is not very much. Only a few hundred kroner every month in salary would be regarded as a material change if it is to the disfavor of the employee. So that also means that if due to the pandemic you are facing a cost reduction and you are asking the employees to reduce their salaries, then if the employees would not consent to such change, then you would have to notify the employee of such change with the individual notice periods for each employee. And that also relates to, for example, reduction in working hours, if the reduction in working hours also is followed with a reduction in salary, which it is typically, because then the reduction in the working hours is regarded as a reduction in salary and therefore also a material change, even for not very much change in working hours. For example, a half hour per week, that would be regarded as a material change. Changing the workplace, that's actually a good question, because we have all, I think, experienced a change in our workplace during the pandemic, because we're all directed to work from home. And there you can see on my slide deck that I have a distinction between permanent changes and temporary changes. And what I mean by that is that an employer has a larger room for temporary changes than for permanent changes. So nobody has really questioned whether it's okay for an employer to ask an employee to work from home during the pandemic. First of all, because the government has asked us to do it, but secondly, also because it's temporary. That also means that if the employer wants to change the working from home to be a permanent situation, that is not something he can do without respecting the individual notice period. If an employer is looking to reduce costs, having to face a waiting period of the individual notice period will sometimes be not possible, because he needs the cost reductions here and now. So that's the reason why an employer during the pandemic would typically go out and ask for consent from the employees to have the salary reductions take effect immediately. And I think many employees facing the alternative that some of their colleagues would have to be terminated, have decided to accept such salary reductions. And to the question whether it's valid for an employee to consent to material changes without respecting the individual notice period, the answer to that question is, as a starting point, that is a valid consent. But in core practice, we also see that if an employee is terminated shortly after having given such consent, then the courts will say the employee gave that consent in order to not be terminated. So when the employee ends up being terminated anyway, he shall not be bound by such consent. At least an employer have to be aware of the risk of such consent be set aside if it is specifically regarded as unreasonable in connection with an individual employee. When we deal with material changes, we always, from a legal perspective, have to bear in mind that it has to be considered for each individual employee whether a change is material or not. And that, of course, would not be so relevant if it's a salary reduction, because as I mentioned, that would normally always be a material change. But if we are, for example, talking about the changing of the working place permanently, if the domicile of the employer is being changed, then if you change the domicile from one city to another city, then an employee who actually lives in the city where the new domicile is located, it would not be a material change for this employee, but it might be a material change for other employees who get their transportation time increased due to the change. So that's just to give you that understanding that material changes always have to be regarded specifically for each individual employee. But then, of course, if you have 500 employees, it's not a possible exercise to make 500 individual considerations. So there you would have to have an overall view at it, and then decide if it is a material change likely for a large part of the employees, then handle it as a material change for all employees, and typically use the longest applicable notice, which would for salaried employees be 6 months, and implement the change with 6 months. But during the pandemic, we have been asked questions that was not even thinkable before the pandemic. Salary reductions was not something we were asked about prior to the pandemic. Postponement of part of the salary payment, which is also something we've been asked a lot about. Can we ask to postpone, for example, 20% of the salary to the employees to be paid out at the end of the year if we have finances to pay out the salary? That was not a likely question to have received prior to the pandemic, but all of a sudden it was a new normal being an employment lawyer. And it's a question we have answered many times. And you need the consent there if you don't have time to implement it with notice. And when you ask for employees' consents, you always have to consider as an employer, if we ask 20 employees to consent to immediate change, what if 18 employees says yes and 2 employees says no? What do you do then? Because you can't solve that question legally, because it is not very solidaric, of course, of those 2 that are saying no. But what does that mean? Because it could be that they don't have the financial possibility to give that consent. So you have to prepare yourself for handling that situation from an HR perspective. Will you then go on and accept the consent from the 18 employees, living with the fact that 2 employees said no, so they will keep their salary, and knowing that if it comes to a redundancy later on, they might be, how can you say, on top of the line for those that are facing the redundancy. When you make material changes, as I said in the beginning, material changes are in fact considered a termination of employment. So when you notify and go through the formal procedure of notifying formal changes, if you meet the threshold under the Mass Redundancy Act of the numbers of employees being affected by these material changes, always keep in mind that then in fact you have to comply with the procedures under the Mass Redundancy Act. That doesn't have to be a huge problem, but keep it in mind that if you are, for example, making material changes to all your employees and you are notifying all your employees and you have more than 20 employees in total, that will trigger the procedures under the Mass Redundancy Act. And as a final remark, also remember that from a formal perspective, the Employment Contract Act calls for the necessity to draft an appendix to the employment contract with the changes to the employment contract, and you have to have that appendix in place no later than 1 month after the changes has taken effect. You don't need the employee's signature on it. You just have to be able to prove that as an employer you submitted an appendix to the employment contract to the employees. So that was my introduction to the subject about changes in terms and conditions.
Anne-Marie, I hope you can all hear me, and I'm terribly sorry for the problems at least some of you had. Very hopeful you can all hear me now, because speaking of remote challenges, I actually just literally yesterday, maybe a little bit too drastic, changed my headset, and apparently that caused some issues for all of you. So I'm now back with my old one, hopefully working. But I'll just finishing a small Q&A for you, Anne-Marie. I'll just try to wrap up very quickly on my own part. But I did listen in to you, Anne-Marie, and I was just wondering, in terms of your practical experiences going through this past year, and speaking of changes in terms and conditions, what has been sort of the predominant type of changes that employers have implemented throughout the crisis?
And the two most often changes have been salary reductions or postponement of part of the salary payment. So in order to make sure that there are finances enough to actually keep everybody on board and not having to make redundancies, a lot of employers have tried to make these temporary cost reductions. And I think we'll come back to that in just a little bit. That has helped a lot of employers, but since it keeps dragging on a little bit, this pandemic, we are now facing a situation where some employers, it's not enough to have these temporary cost reductions. We are now moving to actually having to let people go. I think that's my experience, and I would expect that your experience is the same, Marianne.
No, absolutely. It's going to be very interesting and hopefully not too disturbing to see what the next couple of months will bring. Maybe just a final question for you, Anne-Marie, in terms of, because you were also speaking about this whole general rule that either you, if material changes, which of course salary changes and anything to the detriment of the employees will need to be notified with the individual termination notice, but say that the employees are actually willing to give consent Has this been your experience that employees vis-a-vis unions have been more receptive to actually granting consent for general changes in this environment, and are there any sort of concerns or pitfalls you want to point at in terms of obtaining consent from your employees?
I would definitely say that the employees and also the unions have been very keen on actually trying to help the employer to keep as many as possible in the job. So it is my experience that the employees have been actually willing to accept salary reductions, hold back of bonuses and incentives. You will come back to that in a little bit, and also to accept at least temporary reduction in income. So I think also from an overall perspective, we actually have some employees in many companies throughout Denmark that has had a very solidaric approach to the situation, trying to keep as many as possible in their job.
Yeah, no, I agree with you, and I also think that we have seen also both US-based owned companies, but also in Denmark, that even management would sort of take the front and actually take their significant cuts, maybe temporarily, but as a tool to avoid any sort of further much more grave consequences of dismissals, what have you, in the hope that this is a temporary challenge we're all facing. Yeah, great. And I see also Therese encouraging that in terms of everything we already said so far, please do feel free to post your questions in the chat, and we can either now or by the end bring some of these questions up, and then just to sort of complete my own part in terms of the mental health. I just wanted to sort of wrap up with a few observations, and I believe that I did also mention that I had been spoken with some of the unions, and one of the messages they are also sharing is that the reason why, and that is of course also a phenomenon we generally know from stress-related challenges in general, that they also kindly reminded we were dealing with even before the crisis. But what they're saying very much is that their experience is that when they have members, and apparently they do have members calling their hotlines very vividly these days, that it's very much got to do with the lack of alignment of expectations. Typically, that they are left with the impression that they are expected to work 24/7 and basically be available throughout the entire day and evening, etc., and that is causing a lot of mental disorder with the employees. So that's definitely one of the areas where it seems that that there is room for actually sometimes maybe even quite easily to align expectations, and then also sort of from a legal perspective, I just want to add that in this remote environment, it is, I have to say, just even more important. And I know it's a little bit maybe a boring comment from the lawyer, but the lack of documentation on the employee file and employee handling in this environment is getting even more problematic. So follow-up talks and general sort of performance management processes just needs to be even more lean, both from a legal perspective, but again, coming back to the comment from the employee representatives,
it actually also adds in a positive way to the employee's own understanding of what is expected, and probably also provide some comfort that certain things are not expected but just wrongfully being perceived by the employee. So I think that there are also some good observations here, and if handled well, the one-to-one discussions in many environments can actually be a good thing, and obviously also try to deal with the decision of, is the remote working going to be a permanent feature, or is it just a temporary one? Is also one of the important issues that employers will have to deal with in 2021 for sure. I did have there was a few questions here on and Marie already responded to the statutory order on mental health from September last year, and we can also link it to you after this presentation, so you all have it very easily accessible, because again, the working environment authorities in Denmark, you may say many things about them, and they are not necessarily very much on their toes always, but I would say that within this field, adding also the entire sort of challenges around Me Too, they did provide a lot of stuff that is actually worthwhile reading through, because and I think it is actually because many of this material was actually developed in good cooperation also with representatives of both employers and employees. So just an encouragement for you to read some of that stuff. Okay, but I think then we would move on to our third topic of the day,
Yeah, I think Marianne.
Should we maybe take a few questions, and Marie?
I think Birgitte raised a very important question actually, and it's quite long, so it's perhaps difficult for you to manage to read it. But the question is that if people, for example, are foreigners and they travel home for Christmas holidays, and then they are not able to return to the country, and if you have a requirement that employees have to be in the country they work in, so working from home means working from the country where the employing legal entity is domiciled, what actions could arise from this? What can you do? And I would say, if, Marianne, I'll allow you, of course, also to answer, but I would say from my perspective that's a good question, because you would have to look at whether the employees have actually acted without necessary care in terms of being able to comply with the obligations under the employment contract. So if it was clear when the employee left Denmark that it was likely that the person would not actually be able to return back to Denmark, you might actually stand in a situation where that could be a breach of employment if that was a route you wanted to go down. So you could sanction the employee depending on how clear it must have been for the employee before he or she left the country. But obviously, if the restrictions were made while you were away, it's difficult to blame the employee for ending up in this situation. But of course, you have to make a specific evaluation on that. Do you have anything to add there, Marianne?
Yeah, I think that it is absolutely true. It raises tons of questions, because it actually also raises choice of law issues in terms of, okay, say that an employee maybe not, as you rightfully also mentioned, and Marie, it may be that the employee is to be blamed for what has happened in terms of not returning and everything, but there could of course also be more exceptional circumstances where simply sort of the red zone came up and nothing to do about it, and they are then just it sounds wrong to say stranded in their home country, but that they are stranded then in a different jurisdiction. Would it then be that country's laws applying, even working environment laws, what have you? And if they are stranded, so to speak, in the wrong country for a long time, those questions can certainly come up. From a working environment perspective, I would still I would still say that as a temporary measure, the employer has to sort of adapt the laws of the employment contract. So the Danish sort of principle should apply to that situation to the widest extent possible. But generally speaking, it is the experience that multiple countries took quite a liberal stance on all of these issues, because not to get into details, but we're talking about tax laws, immigration laws, what have you, that also can come into play in these difficult situations. And quite a few of them have actually been solved by various exceptional orders, allowing sort of being receptive and understanding that these situations can occur, and this cannot lead to sort of a complete change of the position of each individual employee. But certainly, you're absolutely right, Birgit, in terms of there has to be sort of diligence exercised in terms of if you have a situation that was intended just to be very quick, you need to address it or revisit it again if it sort of drags along, and make sure you understand the implication and which parties to take the risk. What is the result of it? Results in tax and social security liability, etc. And that is a very relevant question. Again, hopefully, and in many cases, it will not necessarily trigger any tax or social security consequences, because there are various exemptions made in the current environment. But if such consequences are triggered, it will be based on an analysis of the contract. Sometimes you see international employment contracts that would provide for netting out principles, what have you, where the employer kind of took on the risk. As a general rule, and from a very Danish perspective, if it is not provided for in the contract, the starting point would be that would be sort of on the employee's account. But again, that can of course depend on if this employee got stranded in the Middle East due to a business travel, not being able to return, then is that then, so I'm sorry, but it is really a case-based analysis, but a very important starting point is certainly the employment contract. There was also there was a very good question also on sort of the temporary versus permanent, on how to for how long can you basically say that it's only sort of temporary home office work, and how can you maybe do a transition without being obliged as an employer. I guess it's kind of targeting without sort of the employer being obliged to on a permanent basis allow for home working necessarily, and of course due to government restriction and everything right now, everyone should be very safe in sort of continuing in temporary solutions. But as restrictions are lifting, employers should certainly be careful on articulating that. Either it could be articulating that this is sort of a continued temporary testing phase where we are exploring and in order to enable us to make the ultimate decision on to what extent we will allow home working to become a permanent solution. But I think the message here really is that when we are going into this sort of next phase, it is important that the company is not creating expectations unintentionally for employees to actually sort of being left with the impression that, okay, I'm now allowed on a more permanent basis to work from home 2-3 days a week. So the communication around what is the framework for whatever scheme you are applying is super important, so that it doesn't generate legal expectations on the long run. At this current time, I think it would be very difficult for any employee to argue that any legal expectations can be argued in this exceptional environment. But still important to be aware of also individual managers' language when they speak with their employees, and what they put in memos of annual follow-up conversations, what have you. Okay. I am then just gonna do a quick walkthrough on our third selected topic in terms of impact on salaries and incentive schemes, and basically we just wanted to also add this discussion because I think both Marie and I experienced that this has been also very much on the forefront of companies' mindset here, that many have done sort of troublesome experiences that the targets they had been putting out were definitely not very appropriately accounting for this very exceptional circumstance, which both led to actually groups of employees being overly compensated because of actually some businesses doing unexpectedly well. Fortunately, there are quite a few of them also in this group, I believe, that actually even not necessarily benefited from, but actually did very well throughout the crisis, or that there would be groups of employees that actually took a very tough cut, which was not really fair, considering their significant work to basically limit the losses of the crisis. I mean, it can come in many different shapes, but just a general observation that many had to revisit their variable pay schemes, and again, from a legal point of view, we are coming back to very much the same analysis that Anne-Marie touched upon a while ago in terms of, can you actually amend that? If you can, is that supposed to be then with or without notice? And that will be subject to an interpretation of the program, whether that is actually only sort of a year by year program, or whether it's an ongoing scheme. It depends on what is accounted for in the scheme, if you can actually amend the criteria, either amend the criteria from one year to another, or whether, and I think that is at least one observation that many companies decided to actually put in that caveat in their programs, allowing for possibly also revisiting the KPIs or criteria in the course of a financial year, if it turns out that some sort of fundamental criteria or expectations founding the basis for the budgets, that if they were severely hit by circumstances that no one could have expected, such as global pandemics, XYZ, wording like that, we do see that quite a few companies are choosing to actually build into their future structure, because everyone tends to agree that, okay, of course, our employees need some kind of certainty around what KPIs we are dealing with. But on the other hand, it must be reasonable, and most employees do recognize that there is an exception for certain extraordinary circumstances. Typically, in broader LTIP schemes or the like, you would also already have provisions that could account for extraordinary events such as mergers, takeovers, transactions, what have you. And within that bucket, you could also build in global pandemics or any sort of similar extraordinary events that no one could have accounted for. So I think I'm going to sort of wrap this up a bit quickly, but just sort of to alert you all that this can be, and again also because many employees we are in an environment where most employees also have a sympathy and understanding for the necessity to amend structures. So it is also for that general reason a really good time to consider whether some of these elements and criteria needs adjustment to create a little bit more flexibility and protection for the companies under these programs, also considering caps if something goes absurd. That is also a consideration.
Thank you for that, Marianne. And I think just as a add-on information, if you make changes to your bonus schemes that will significantly reduce the employee's possibility to accrue the bonus, that might be a material change, and that'll take you back to what we just went through. But Marianne, I was wondering, I think we have had a lot of questions regarding clients calling us and say, well, our bonus scheme is discretionary, so I guess we don't have to pay any bonus for 2020 because it's at the company's discretion. What would be your answer to that question?
Well, my answer is definitely that the language around discretion is often comes in handy and obviously creates a level of recognized flexibility for the employer, because it is also that type of language that alerts the employee to not necessarily expect anything firmly from one year to another. But having said that, and quite a few of you are probably also very, very much aware of this provision we have in the Danish Salaried Employees Act, Funktionærloven, Section 17A, which provides a principle basically saying that entitlement to bonuses can also be established by way of usage or practice. And that essentially implies that in a situation where the employee has received a certain level of bonuses for the last 3, 5, 7 years, it becomes pretty difficult to then all of a sudden argue that we are now pulling the discretion card and you're getting zero. On the other hand, it may be that it's absolutely okay to do that, because if the fundamental basis is that we are exercising discretion, but by the way, we also came out for the very first time with a minus result, then the discretion is absolutely well objectified. So it basically, I guess what we're just saying here, Anne-Marie, is that discretion is certainly not the answer to everything, because it needs to be a little bit more careful analysis around whether expectation and thus a legal obligation could also be based on prior practices. So it's not necessarily just the straight line to defending a zero bonus.
It's not a magical formula, but I think that was a great answer, Marianne. I have another question for you, which is also a question we very often receive. Does the employee have the right to negotiate salary every year? And if they do have a right to negotiate salary, do they also have a right to get a salary increase?
Yeah, and again, that can very much depend on what the contract says. Many employment contracts would typically have a provision that at least allow for an annual salary discussion, salary negotiation. But if that is sort of accounted for in the contract, that needs to be respected. but it will not imply that there is any obligation to literally grant an increase unless, again, that is clearly stipulated in the contract. On these salary reviews, just also a clear reminder to, and again, this can also get more difficult in this remote environment, but to remember all these especially female on maternity leave, because again, you cannot forget about them. They need to be also subject to salary review as anyone else, if that is what they are entitled to, also during absence. And then also, Anne-Marie, we should of course mention that collective bargaining agreements may also add to the employer's obligations, both in terms of salary reviews, but certainly also maybe even granting mandatory increases and local negotiations. So that's also an important point to be aware of.
Thank you, Marianne. And I think in order to also have time for the last subject, please move on to slide number 4 regarding the legal framework for conducting redundancies. This one, yes, thank you. And as I mentioned briefly when I was talking about material changes, if you have not been able to make cost reductions that will help you continue your business, you might end up in a situation where you have to move to conducting redundancies and terminate some of your employees. I think what we experienced in the beginning of the pandemic was that, to use a Danish picture, if you shake the apple tree, some rotten apples will fall down. And that often happens when you have a financial crisis, that on the short run, you will use the opportunity to terminate some of the employees that you were kind of, not too satisfied with anyway. So that will be done on the short run. But in the long run, you might end up in a situation where more significant cost reductions are necessary. And when we advise regarding termination of employments, we always have to get the legal landscape clear from the beginning. We are, first of all, looking at which type of employees are we talking about? Is it salary employees? Is it blue-collar workers? Is it somebody that falls outside mandatory Danish law, for example, general managers? And is there any collective bargaining agreements in place that we have to be aware of before we even start to think about terminating employees? But having gotten the overview of the legal landscape, there is a clear distinction between individual terminations, where it's only one or few employees, and a situation where you end up in having to conduct mass redundancies. And we'll come back to the thresholds just as a brief info for you in just a second. But the mass redundancy procedures are triggered if certain thresholds, the number of total employees and the number of employees to be terminated, are met. But say that we are now looking at having to conduct a certain number of terminations. We have to select between all our employees who to terminate. And as a starting point, the employer has the managerial right to decide who can the employer best live without. So it's a clear principle that that's the starting point. But there are some very, very important exemptions to that starting point. And that has to do with the protected employees and relates to my point being discrimination here. So we always have to get an overview. How many protected employees do we have in our company? Protected employees could be disabled employees. And there you have to be aware that also some employees on long-term sick leave, who you would normally not consider as disabled, might be disabled under the equal treatment regulation. It could be also another group of protected employees. Of course, everything that has to do with pregnant employees, female employees on maternity leave, fathers on parental leaves, and so on, they would also be protected. And you have the shop stewards, the employee representatives, all so in the working environment, the Works Council and the Working Environment Council, and if you have employee elected board members. So you have to be completely aware if you have those amongst your employees. And it's not because you cannot necessarily terminate the employment of the protected employees, but you have to be careful and you have to make the strict analysis whether there is nobody else that you can actually choose in that connection. So, and to that end, age is also a relevant criteria to be aware of if in connection with a larger reduction of your staff, there is a drop in the average age amongst your employees. That might, for some unions, be used as an indication that the employer has actually taken the opportunity to terminate the employment of the oldest employees apart from all the other employees. So that might give rise to claims for age discrimination. So you have to be aware that it's not a magical formula that we have a pandemic and that you are really suffering as an employer and have to make cost cuttings. If you choose a protected employees and you do not have the proof to establish that this person was not chosen because she was on maternity leave, then it might be the opposite of a cost-saving exercise. The compensations we look at here are typically 6, 9, 12 months salary on top of the salary during a notice period. So, and being an employment lawyer, we really prefer to be asked ahead of conducting the terminations rather than after the notices have been served. Because once the notices have been served, it's binding upon both the employee and the employer. So when it has been served, you have exposed yourself as an employer to claims for discriminations. On my slide here is also unfair termination. First of all, you of course have to decide this employee who is being terminated, is that somebody who is protected against unfair termination? Salaried employees would be protected after 12 months of employment. Other employees might be protected under a collective bargaining agreement. But the unfair termination would typically not come into play if you use the reason that you are reducing staff, you are laying down a position. Then it's difficult to raise a claim for unfair termination. We do not have a principle like in Sweden where you have last in, first out. As an employer, you have to terminate those employees that lastly joined your company. In Denmark, you can't choose somebody with a longer seniority. You just have to be aware that if you choose somebody with a very long seniority as opposed to somebody with a short seniority, the claim for unfair termination may arise. Here, as everywhere else where we are conducting redundancies or termination of employments, it's of course possible to enter into voluntary severance agreements. And in particular, in those situations where you are dealing with protected employees, that's an instrument which we would very often use. But of course, generally, if it is a cost-saving exercise, your possibility as an employer to offer rich terms on top of what the employees are entitled to are typically not possible or relevant. So what you could normally offer would be to put people on garden leave, for example, or you could offer to waiver the right to set off in salary earnings that employees would have if they take up new employment during a garden leave period. Or even if you do have finances to offer an outplacement, that could also be something that could come into play. If you can just briefly move the next slide, so I will just let you be acquainted to the thresholds that applies regarding the rules on collective dismissals. Be aware that if you are subject to a collective bargaining agreement, there might be special rules on mass redundancy in your collective bargaining agreement. So these rules here only applies if you are not subject to separate rules regarding collective dismissal rules in a collective bargaining agreement. But here you can see that the rules does not kick in unless you have at least 20 employees. And then you have to meet the thresholds depending on the size of your company before the obligations are triggered. The obligations are twofold. It is both an obligation to inform and consult representatives amongst the employees, and it's also an obligation to inform the authorities that a larger group of employees are becoming redundant. But it's not that big a nightmare to have to comply with these rules. You just have to be aware of it, have the documents ready. You can do it actually in very short periods, few days actually, if that's necessary. That's not preferable. You should allow to have time enough to inform and consult with the employees. But we have conducted mass redundancies actually over a 2 or 3 days period, just to let you know that if you have to follow the rules, you have to follow the rules and don't try to avoid it. That was my points on the redundancies. Did we get any questions regarding that?
We actually didn't so far, but of course, welcome you to post anything here. But Anne-Marie, I was wondering in terms of the thresholds and everything. We see sometimes a company, even though, and I absolutely agree with you that in Denmark it is in fact quite lenient and easy to go about the formal requirements, right? We do not have requirements for social plans or employees needing to agree to a certain framework for conducting the collective agreements redundancy. So it is certainly easier. But if there is an appetite to avoid anything being framed as a mass redundancy, is it any issue to sort of plan your redundancy exercise to have X numbers in one given 30 days, then another number in the next 30 days, to basically salami it all up to avoid the formal requirements? Is that okay?
Yeah, you mentioned the 30-day period, and that's the starting point. The law says that if you conduct this number of terminations during a 30 days period, then the rules apply. So that the clear starting point as an answer to your question is that if the termination does not take place within the 30 days, then the rules does not apply. But you have to be aware that, at least in theory, we always make the reservation that if you had in fact decided that you wanted to terminate 50 employees, but you cut it up like a salami to avoid the procedure, we would expect that you could risk a claim for intentionally trying to avoid the trigger of these obligations, and you're doing it in bad faith. But it would, of course, be necessary for a union or employees to be able to prove that the decision by the employer was actually taken prior to making the redundancies. So the employer would always say, well, we had to take 1 month at a time because we didn't know how things were going. But if you have, for example, a summary from a board meeting or anything establishing that this was what was going to happen, you would be able to lift that burden of proof.
And then I guess also that if you would want to sort of slice it up like this, even though it's legally permissible and maybe even justifiable, then it is always, of course, the balance from a management perspective, whether you would rather have the very clear communication that we now did what we believe was needed, and we can now sort of calm the organization down, that at least for the next 6 months, what have you, even though it's difficult in these times, but the risk is, of course, in a very sort of sliced up redundancy exercise, that it keeps being a lot of turbulence in an organization. So also from that perspective, something you should think carefully about whether that is actually worthwhile to avoid these fairly limited formal requirements. Okay, great. Thanks a lot, Anne-Marie. And I was also wondering, I think we also sometimes see this question that you have a larger redundancy exercise, and then reality is that you at the same time also have the situation where one given person is selected for redundancy, but the very same person is actually also on a bad performance track, or there are personal or individual performance issues with this individual. Can you say something about what would be sort of typically the recommendable or the right reason for this dismissal, or what the thoughts are about that?
That's a great question. I think when you are making redundancies, you should always use the reason that the person is being made redundant, the position is being cut away, because there is a clear distinction between a reason that is related to the situation of the company and the reasons that are related to the employees. And if we're talking about the reasons related to the employees, we would always require prior written warning and reasonable time to improve in order for termination to be reasonable due to the bad performance, if that was the case. So always use the reason that you are cutting away the position, you're laying it down. That also means you cannot recruit another replacement immediately after having cut away that position, unless something very significant actually happened that you could not foresee at the time of serving notice of termination. So the clear recommendation would be that you would use the recent cut down of the position. But when you make your selection criteria, performance could of course be part of when you choose for, if you have 10 employees in similar roles and you have to choose between those 10 employees, the selection criteria could be performance, flexibility, qualifications, and so on. So there it could be a relevant issue, but don't use it as the reason for the termination.
Yeah. Perfect. Thanks a lot, Anne-Marie. And just we have a few questions that we should just address here. And before doing so, just a small remark on my side in terms of severance agreements, because as Anne-Marie mentioned, of course, they are very widely used and recognized in Denmark. But just also alerting you that sort of the recommendation to actually allow individual employees to consult with the union or any sort of advisor is always a very good thing, but it is also our experience that it is in fact a very relevant thing to be aware of these days, where we are literally putting people onto unemployment, and thus the risk of being challenged for the validity of these severance agreements is higher at the moment, just to sort of make that alert. a good question here from Marianne in terms of if you have parts of your business being shut down due to the pandemic and other business areas being open, whether you can impose holidays or time and year taken during these restrictions to basically get some of the cost savings imposed on the employees being put out of business for a while, and I guess again the question, the answer depends on what is permissible under your working time arrangement in terms of time and year. But very likely it would be an option, and likewise for the holiday, our general observation or reservation would be that if the question would also target a situation where you have the government compensation schemes in place, then there are certainly restrictions in terms of what you can actually do in terms of holidays. So there needs to be a distinction on whether these people are literally, so to speak, only sent home, or whether we are under any of the government-supported compensation schemes, because then there will be several restrictions that will apply in terms of what you can do in terms of holiday, etc. Birgitte, you also had a question in terms of merit increase being delayed, and to the extent that proposal for a merit increase then did not compensate for the later adjustment of the salary, and I think that question really comes back to an analysis of what is the legal entitlement in terms of the merit increase. If in fact there is a contractual entitlement for an increase and that is then being delayed, then we have a clash and a potential sort of material change that needs to be addressed, as Anne-Marie previously sort of elaborated on. But I'm getting the impression that we are more in sort of a merit increase in the ordinary course of business now being delayed, among others, due to the crisis, etc. And in that situation, it is very likely. You're now elaborating that you did already sort of state that you adjust the salary, and if that implies that you have basically committed yourself to adjusting it, maybe even committed yourself to adjusting it specifically and then delaying it, then there is a mismatch between what you have articulated as what seems to be a potential legal promise and what you're actually giving to the employee, because they are then short on actually receiving their increase in due time, and thus receiving a loss for those months if they are not duly compensated, and that, I have to say, sounds to be a potential sort of maybe not breach, but something that needs to be sort of notified. And if that is pending, that could definitely be a tricky one, because breaching what the employees may rightfully perceive as a contractual promise is not a good thing. So that is definitely worth analyzing and see if you can possibly defend that. And I'm sure that there are more details to this, but it could be a challenge for sure. You're welcome. I think we hopefully got through all of the questions, and over to you, Therese.
Yes, thank you, Mariana. I just want to tell everybody that we are going to do an informal Q&A. If you have time to stay on the line, we will do an informal Q&A to about 10:30. I just want to do a quick wrap up by saying thank you to Mariana and Anne-Marie for sharing their insights today. It's fantastic. I think we could talk about this for several more hours. I just want to make one announcement before you leave the call. The HR committee is going to be announcing its Agile HR theme for 2021 very soon. The program will feature four events on the topic. First, in Q1, we will have HR's role in business agility and building business value. In Q2, the employee experience and driving engagement. Number 3, leadership during crisis, that'll be in Q3, and then in Q4, we'll do workforce planning and talent attraction. So keep your eyes out for that. We hope to see you during the year attending some of those interesting events, and be sure to spread the word to other HR professionals in your network. So thanks for joining today. We look forward to seeing you in person later this year.